I'm a young black man doing all that I can to stand. Oh, but when I look around and I see what's being done to my kind every day, I'm being hard to this prey. My people don't want no trouble. We've had enough struggle. I just wanna live. God protect me. I just wanna live. I just wanna live.
Just gotta get some things off my chest. Tough times, I hope y'all holding up. We'll be hype, cause we always is. Don't feel like this.
How many mothers have to cry? How many brothers gotta die? How many more times? How many more times? How many more marches? How many more signs? How many more lives? How many more times? Take a look around. Can you see it now? Don't be colorblind. Cause when they're killing mine, they'll try to justify. Oh, each and every time. Playing in the park, taking a jog, sitting on the couch, in your own house. Never seen a matter what we do. You think we don't matter, but we do. You got a problem cause the city on fire. But you're quiet when niggas die. Let the soul about their body that we bury. You a guy now, you no longer have to worry. It's so hard to sing these words out loud. All these beautiful, precious black lives lost in the name of senseless white pride. Tears falling from our eyes. How many mothers have to cry? How many brothers gotta die? How many more times? How many more times? How many more marches? How many more signs? How many more lives? How many more times? Tell me, how can you be quiet? You know the language of the unheard is a riot. All we ever see from you is violence. You know you ain't no better if you silent. You talking about the city on fire. Where your rage when my people die. We ain't slaves, let my people fly. Now it's time, watch my people rise. How many mothers have to fall? How many brothers gotta die? How many more times? How many more times? How many more marches? How many more signs? How many more lives? How many more times? How many mothers have to cry? How many brothers gotta die? How many more times? How many more times? How many more marches? All across the world. How many more signs? How many more lives? Hey, what God, how many more times? I leave you die.
trial of Derek Chauvin now in the hands of the jury in Minneapolis. Attorneys on both sides making their final case to jurors who must now decide if the former police officer is guilty of murder. Eyewitness News reporter Veronica Miracle is live now with more, including a last-ditch effort to declare a mistrial. Veronica.
Well, David, those jurors have gone home for the evening, but they will be back deliberating again behind closed doors first thing tomorrow morning. Meanwhile, as you said, California Representative Maxine Waters also making headlines regarding the case.
12 jurors now deliberating the fate of former Minneapolis police officer Derek Chauvin. They will decide if Chauvin is guilty of second-degree unintentional murder, third-degree murder, and second-degree manslaughter over the death of George Floyd. In their closing arguments, the prosecution telling the jury to remember the unforgettable video that sparked worldwide protests.
Use your common sense. Believe your eyes. What you saw, you saw. For 9 minutes and 29 seconds. He begged, George Floyd begged until he could speak no more.
In their final statements, the defense arguing George Floyd's underlying health problems and drug use killed him, not Chauvin. Medical experts rejected that theory during the trial.
Did Mr. Floyd die exclusively of asphyxia, or were there other contributing factors?
As the jury now deliberates their decisions on the 3 charges, an anxious country awaits a verdict. Civil unrest now potentially affecting the case. Representative Maxine Waters making these comments about the trial.
I hope that we're going to get a verdict that is say guilty, guilty, guilty. And if we don't, we cannot go away. We've got to get more confrontational. We've got to make sure that they know that we mean business.
The judge denied a request for a mistrial over her comments, but says the defense may have grounds for appealing a guilty verdict later on.
I wish elected officials would stop talking about this case. Their failure to do so, I think, is abhorrent, but I don't think it has prejudiced us with additional material that would prejudice this jury. They have been told not to watch the news. I trust they are following those instructions.
David, it could take hours, days, even weeks for the jury to come back with a verdict. Chauvin faces potentially decades in prison if convicted on all 3 charges.
Hello, I'm Mark Brown. Get more great ABC7 content by clicking the subscribe button for our YouTube channel. And download the ABC7 Los Angeles streaming app on Fire TV, Android TV, Apple TV, and Roku to watch on your TV.
To help us unpack today's closing arguments in these last few weeks of the trial testimony, we bring back ABC News contributor and host of the Law and Crime Network, Mr. Brian Buckmeyer. Thanks for joining us again, Brian. Let's start out with the prosecution's closing argument. On day 1, during opening statements, the state played for the jury almost in its entirety that excruciating 9.5-minute video of George Floyd as he died under the knee of Derek Chauvin. But they didn't do that in closing arguments. Why do you think that they made that choice? And what was their main message to the jury today?
So, Lindsay, I think they didn't play it for the jury because the video has kind of been oversaturated. They've been playing it so many times and so often that I think the fear is that they could be kind of beating a dead horse, sorry to use the phrase, but that also is a problem. They should have anticipated that, and I think it would have been smarter to maybe play the video a little less in the beginning of the trial and leave it for the end. This is the case, what you've been arguing, that the video is why Derek Chauvin is guilty, and to not play that in its entirety for the jury, especially when Eric Nelson is saying that it's more than the 9 minutes and 29 seconds, I think that was a misstep by the prosecution.
And the prosecution was certainly very meticulous about walking through each element of the crimes that Chauvin's been charged with, especially that top count of second-degree murder. Does that show really what their ultimate focus is?
Yeah, it shows me that the prosecution is here to get that top count of unintentional murder in the second degree. They walk through each and every element as most seasoned prosecutors would do, but they did a great job of weaving in the facts and also weaving out some of the arguments that Eric Nelson was raising, kind of showing why some of them were ridiculous, strengthening their arguments, and showing why each and every element and each and every charge was made out, and not just settling for the lower or lesser included charges.
And we just heard this in Alex Perez's piece, but want to play this again. This is how the state wrapped its case with this final message.
You were told that Mr. Floyd died because his heart was too big. You heard that testimony. And now, having seen all the evidence, having heard all the evidence, you know the truth. And the truth of the matter is that the reason George Floyd is dead is because Mr. Chauvin's heart was too small.
Regardless of which side you're on, you have to admit that was kind of a mic drop moment. How was that for a closer? And on the issue of the cause of death, do you think that the state left reasonable doubt that it could have been the drugs or heart condition that killed George Floyd?
So a few things there, Lindsay. I heard what Attorney Blackwell said in terms of that great analogy as to using the heart of George Floyd and kind of dispelling that argument while talking about the heart, or maybe lack thereof, of Derek Chauvin. I heard it, but I didn't feel it. I would have expected from Jerry Blackwell to give a more impassioned ending to that, especially on such a passionate case. In terms of the reasonable doubt, I think that most, if not all, doubt, especially reasonable doubt, has been pushed aside here. For the most part, it's going to be the jury walking through the charges and seeing what fits and what doesn't. It's a 14-page jury instruction that the court gave to the jury, and they're going to have to walk through each and every one of those elements. But Eric Nelson was able to raise some strong arguments. The question is, are those arguments going to uphold the prosecution's large number of witnesses and testimony in this case?
And let's turn to the defense now. We heard so much about that so-called reasonable police officer who may have had more information than the bystanders can see or what the video can show. How well would you say that the defense argued that, judged by the standard of reasonableness, Chauvin is not guilty?
Not well, in my opinion. I'm not quite sure what Eric Nelson was attempting to do. When I represent someone as a public defender in Brooklyn, I am representing a person, Mr. Smith, Miss Jane. I don't represent this hypothetical reasonable officer, and I thought that was a big problem with Eric Nelson's closing arguments. He seemed to distance himself from Derek Chauvin, only talking about Derek Chauvin and what he did in terms of approaching the vehicle of the officers, seeing the scene, and then move to this hypothetical reasonable officer, never really making the connection between who he was speaking about and what actually Derek Chauvin did. And I think that was a big misstep by Eric Nelson. It made it seem very sterile and not very much like he accepted what Derek Chauvin did, and that he accepted that it may not be criminal, which is something a defense attorney has to do.
And Brian, after the jury was sent away, defense attorney Eric Nelson filed a motion for a mistrial based on comments over the weekend from Congresswoman Maxine Waters. When asked what people should do if Chauvin is acquitted, this is what she had to say.
Well, we got to stay on the street, and we've got to get more active. We've got to get more confrontational.
Got to stay on the street, get more active and more confrontational were her words there. The judge denied the motion for a mistrial, but indicated that the Congresswoman's statement could be an issue on appeal. Is this a potential problem for the state?
I think it could be an issue for appeal. Very unlikely that it will be. If Derek Chauvin is convicted, the first thing an appellate court's going to look at is just the volume of evidence against the defendant, that being Derek Chauvin. And if it is so much so that that evidence would have proved his guilt, but for or excluding what Congressman Maxine Waters said, they're going to consider this to be harmless error. But I think it is very dangerous for anyone to be throwing out that type of language while the jury is deliberating, because even if we get a conviction today, and that is what many people are hoping for, praying for, looking for, that could easily be undone because of the words that occur during the deliberation. So if you want this verdict to stick, you've got to be mindful in what you're doing, not only in the court, but outside the court, because Eric Nelson is listening and he's going to try to push for that mistrial.
And Brian, just one last question to you. You may not know the answer to this, but how late are the jurors able to deliberate until each night?
So the jurors are going to be able to deliberate until 7:30 p.m. Central Time each night. At that point in time, Judge Cahill will allow them to recess into their own hotel. Remember, they're going to be sequestered throughout the pendency of this case, so they're going to be having long days from about 9 or 9:30 in the morning all the way until 7 or 7:30 p.m. But if we get a verdict later on in that day, Judge Cahill has told us that he's going to hold that verdict until the next day, hoping to give us that verdict sometime in the morning so that the city, the state, and the country can prepare for that verdict.
Very interesting information. Thank you so much, Brian Buckmeyer. Appreciate you.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.
For that, let's bring in ABC News senior legal correspondent and analyst Sunny Hostin and jury and trial consultant Joellen Demetrius. Good morning to you both. And Sunny, I want to start with you. As the former prosecutor, what's your take on this jury?
You know, juries are, as TJ mentioned, loath to convict police officers, especially because it's counterintuitive for many jurors because they feel that police officers' role is to protect and serve. And I think that is why you see so few police officers being held to account when you see the death of unarmed black men. I think that this jury is a diverse jury. We're talking about 7 women, 5 men. We're also talking about a racial diversity. And I think that's going to be important because we do know that there is a difference in the experience of policing when it comes to different racial groups. And so I suspect that race will be a factor in the jury room.
And Joellen, what strikes you about the jury?
Well, first of all, I concur with Sunny on her overview of the jury. I would also say what's unique about this jury is that in jury selection, what we saw was each side picking what's was picking those people who believe in law enforcement, those people who probably are Caucasian, those people that are older, those people who perhaps had businesses or were concerned about businesses being burned down, whereas the prosecution was looking for what's traditionally a defense jury, and they were looking for probably people of color. They were looking for potentially lower socioeconomic levels. So that's what's first very uniquely different about this jury.
Sunny, the jurors have 3 charges to consider. So how do you see that playing out as they deliberate?
You know, they're going to be looking at second-degree murder, third-degree murder, and also second-degree manslaughter. The second-degree manslaughter only requires culpable negligence. So that is the least culpable charge. And I think it's going to give them the opportunity to reach a compromise verdict, because there may be some jurors that feel like second-degree murder, third-degree murder, those are sort of depraved mind charges. They may not be able to get there because of some of the factors that are at play here, the fact that there's a police officer, former police officer, being charged. So I think that rather than jury nullification, where you see a jury say, you know, nope, there's no way I'm going to hold this person responsible, when you have a lesser charge included on the charge sheet, perhaps you have a meeting of the minds and you have a jury reach that sort of compromise verdict.
Joellen, are there other factors outside of this case that could influence the jury?
Oh my goodness, absolutely, and I'll point to 4 of them. The first is the fact that there was the civil settlement between the city of Minneapolis and the Floyd family of $27 million, even though the judge has told them throughout the entire trial not to read or listen to anything related to this case. You know, it'd be pretty tough to avoid that. So that's number 1. Number 2 is the fact that just over the weekend, while these jurors were not sequestered, one of the defense witnesses had a severed pig's head delivered to a home that was his former home with blood on it. That's rather disturbing. Third, there was the Dante Wright shooting also late last week, literally miles away from Minneapolis. And you've got the shooting of the 13-year-old in Chicago. So even though they may not be paying attention specifically to things revolving this case, they're going to be hearing about these other components. And I've said from the very beginning, this jury has to be very concerned about their own security bottom line.
Good point there. And Sunny, what signs would you be looking for as far as jurors asking questions?
Oh gosh, this is the worst time for lawyers, by the way, trial lawyers. You're sort of like reading tea leaves when jury questions come in. I think you're usually looking for perhaps a question for the readback of testimony that's favorable to your case. You may be looking for clarification for jury instruction that you think is favorable to your case, but ultimately it's all in the hands of the jury at this point, and you feel pretty helpless as a trial lawyer.
I want to thank you both for joining us this morning. We really appreciate your insight.
Well, hey there, GMA fans. Robin Roberts here. Thanks for checking out our YouTube channel. Lots of great stuff here. So go on, click the subscribe button right over here to get more of awesome videos.
Otherwise, we are in recess until we hear from the jury.
In their final words on the most highly charged U.S. civil rights case in decades, prosecutors told jurors to trust their eyes.
But for the defendant's actions, pushing him down, would George Floyd have died that day? Was it drugs? He just miraculously die of a drug overdose in that time? Maybe it was the tailpipe. Maybe it was his enlarged heart. Maybe not. Use your common sense. Use your common sense. Believe your eyes. What you saw, you saw.
What the jury saw was the same 9.5 minutes the world saw of then Minneapolis police officer DEREK Chauvin kneeling on George Floyd's neck until paramedics carried off his lifeless body. In a case that started with an allegedly fake $20 bill and ended with protests and riots across the United States, prosecutors said the evidence proved Chauvin used excessive force, choked the life out of Floyd, and refused to render medical care even after he showed no pulse.
Roll on the side.
And at the time of causing the death, the defendant committed or was attempting an assault in the 3rd degree. And that's been proved beyond a reasonable doubt. With those being proved in the venue, right, 2nd degree felony murder, the defendant is guilty.
The defense argued that Chauvin held Floyd face down just as he was trained to.
Was putting Mr. Floyd in an eminently dangerous act. We've heard a lot about the prone position. Consider just the basic prone position. People sleep in the prone position, people suntan in the prone position, people get massages in the prone position. The prone position in and of itself is not an inherently dangerous act. A prone position during restraint is not an inherently dangerous act. It is routinely trained and used by the Minneapolis Police Department.
Defense lawyer Eric Nelson blamed bystanders for Chauvin's failure to administer life-saving CPR, saying he felt unsafe. And hoping to give jurors enough reasonable doubt for an acquittal, he offered a broad array of alternative theories for Floyd's death: heart trouble, drugs, even car exhaust.
We have to analyze this case from the perspective of a reasonable police officer at the precise moment with the totality of the circumstances when it comes to the use of force.
Chauvin's fate now lies in the hands of the jury, which is in isolation until they can render a unanimous verdict. One reason for sequestering them is to make sure they don't hear news of protesters demanding Chauvin's conviction. But with demonstrations across the country, it's not clear they won't be able to hear protests from where they're deliberating. Deliberations can range dramatically in length. In 1992, it took 7 days for jurors in the police beating of Rodney King to find 4 officers not guilty. 3 years later, jurors took less than 4 hours to declare O.J. Simpson not guilty of murder. For Chauvin and for residents of Minneapolis and cities across the U.S., that wait will be filled with anxiety and fear for what comes next. John Hendren, Al Jazeera, Minneapolis.
Joining us now, George Floyd's brother, Philonise Floyd, who was in the courtroom for Monday's closing arguments, and Ben Crump, the Floyd family attorney. Gentlemen, good morning to both of you.
Good morning.
Well, I want to talk to you about Maxine Waters and those comments in just a moment, Ben, but let's start with a phone call that you got yesterday. I was there in the room when President Biden called. Philonise, what did the president say to you? What did you say to him? And what was that like in general?
It was just, he was just calling. He knows how it is to lose a family member, and he knows the process of what we're going through. So he was just letting us know that he was praying for us and hoping that everything would come out to be okay. That's basically it.
Philonise, before the trial started, we had a conversation here on Today, and you told me that you thought this was a slam dunk. After being in that courtroom, after testifying before the jury, do you still feel that way? What do you make of the prosecution's case? What do you make of the defense's case?
Well, I'm optimistic about everything. Me and my family, we pray about it every day. I just feel that in America, if a black man can't get justice for this, what can a black man get justice for? So it's just a pivotal point in life. And I think a case of this magnitude, and for people all around the country, they're waiting on this verdict. And hopefully it will be the way that the world wants to see it, because the video is facts and it's proof of what happened. We just need Minnesota to make the right decision.
To that point, Philonise, as we all await this verdict, not just there in Minneapolis, but around the country, around the world, do you have a message for folks? There's, as you know, a lot of concern that there could be more violence, regardless of the verdict.
I just want everybody to understand that it has never been anything like this in life. This has been a motion cinema picture everybody watched around the world. We just want everybody to be peaceful, but at the same time, I can't stop people from doing the things that they're doing, because people are in pain, they're hurt, they're looking. Dante Wright was just killed 10 miles away from where we were in the courtroom. We just want everybody to get it together and understand that we can't live with each other in unity. And we stand in solidarity with everybody across America.
Mr. Crump, I wanted to get your take on the reporting out of the courtroom after the closing yesterday. Judge Cahill chastising Congresswoman Maxine Waters and other public officials for their comments on the case. When you heard that, what was your reaction, Ben?
Well, I thought it was the defense's desperate attempt to distract us further. You know, the jurors have been given the instructions to only pay attention to the evidence that happens in the court of law and not to watch TV and watch the news. And I believe the jurors are following the instructions of the court. And the only thing I will say is it further demonstrates this notion of two Americas, because I have never seen when a black person is on trial for murder, anybody cares about whether or not they can get a fair trial of what people are saying in public. It's only when there's a black person killed by police that we come up with all these distractions, Craig, to say, oh, we want to give every opportunity for the officer to be exonerated. And that's why the whole world is on edge, because history has said people will do anything to justify the killings of unarmed black people by the police, and we can't continue to have that.
Ben Crump, thank you, sir. Philonise Floyd, we continue to think about your family. Thank you as well. And a reminder, folks, as soon as there is word of a verdict, NBC News will bring you live coverage from the courthouse there in Minneapolis.
Hey, thanks for watching our YouTube channel. Find your favorite recipes, celebrity interviews, uplifting stories, shop our favorite
The other officers involved in the incident were fired from the department. The outrage that followed George Floyd's death, I don't have to tell you, ignited nationwide, even global racial unrest, protests over police use of force. In the past 3 weeks, the jury has heard from a total of 45 witnesses, with the most crucial testimony really coming from those at odds over exactly what caused George Floyd's death, if drugs were a factor, and if Derek Chauvin violated policy with his actions that day. Now the prosecution and defense have one last chance to make their case before jurors are sequestered for deliberations. So those closing arguments are set to begin shortly. NBC's Gabe Gutierrez has been following the trial all along. He joins us from outside the Hennepin County Courthouse. Those closing arguments, Gabe, set to get underway very soon.
Yeah, that's right, Kate. And this is a city on edge. Behind me, you can see this military vehicle that has been here for weeks. Now, more and more National Guard troops have been seen in and around Minneapolis. Some 300,000 troops have been activated in this region, some sooner than expected because of the shooting nearby just a few days ago in Brooklyn Center. Now, all eyes are on the courthouse behind me, though, because in just a few minutes, closing arguments are set to begin. We're expecting the prosecution to get its closing arguments, potentially play some short video clips, and ask jurors, as they did during opening statements, to believe their eyes. The prosecution saying that George Floyd died due to the actions of Derek Chauvin. Now, the defense is expected to come after. The defense has been arguing during this trial and calling 7 witnesses to do so that George Floyd died from a variety of factors, not Chauvin's knee on Floyd's neck, but rather underlying health conditions as well as drug use, and that the officers were distracted by bystanders at the scene. After the defense give its closing arguments today, Kate, then the prosecution is expected to give a rebuttal, and then the judge will give the jury its instructions. As you mentioned, Chauvin facing 3 charges. It's possible, Kate, that the jury could get the case within the next few hours, and then jurors will be sequestered. Kate?
Yeah, Gabe, thank you. I know you've been reporting that this could all happen very quickly this morning, or not. We just don't know. NBC News legal analyst Joyce Vance is a former U.S. attorney. She's a professor at the University of Alabama School of Law and also an NBC News contributor. Let me go to you next about the prosecution. We mentioned all the witnesses. When you look at the split, the prosecution called 38 of those witnesses and set up a pretty dramatic case. What do you think they need to do today?
So we won't see high drama here. This won't be like television closings. The prosecution needs to be good technicians of the evidence today. This is their chance to remind the jury of all of the evidence, to encourage them to not be led astray as the defense tries to single out individual pieces of evidence and argue that that one piece of evidence might be weak, and to tell the jury that if they look at all of the evidence as a whole, from the early witnesses on the scene, the bystanders, to the medical experts, that this is a rock-solid case of proof beyond a reasonable doubt. And of course, the jury will consider 3 charges: murder 2nd degree, murder 3rd degree, and manslaughter in the 2nd degree. I suspect the prosecution is really focusing on murder 3 here, but police cases are tough to convict in. Any conviction here will be a victory for justice.
Joyce, just quickly on that, for those who haven't followed this so intimately, can you explain? There are these 3 charges, and potentially the jury could find individually guilt on any or all of those charges, or none, right?
That's right. It's a little bit confusing. The judge will ask the jury to consider each of the 3 charges separately and return a separate verdict. So they could convict, acquit, or what's called hanging, be unable to reach a unanimous decision on each of those 3 charges.
All right, Joyce Vance, stay with us. Thank you. Let's turn to criminal defense attorney and NBC News legal analyst Danny Savallo, who's with us as well. Danny, the defense didn't call quite as many witnesses. What did they need to do to convince at least one juror that there's reasonable doubt?
The defense routinely will not call as many witnesses. There are many defense attorneys, me included, who have simply rested their case after the prosecution rests, calling no witnesses or evidence at all. And the reason for that is that the burden is always with the prosecution. It never changes. It stays with them throughout the case. And the defendant, my client, is cloaked in the presumption of innocence. And that's why you typically see a prosecution sometimes engage in overkill, but often put on as many witnesses as they can without being cumulative, and the defense putting on less witnesses so that they don't do anything to snatch defeat from the jaws of victory if they're already ahead. Now, strategy-wise, what the defense needs to do is push its 2 major themes. Number 1, causation. The neck compression and subdual restraint did not cause George Floyd's death. It was his poor health, it was his methamphetamine use, and his fentanyl use. And central to that is going to be the testimony of Dr. Baker. Yes, that was the prosecution's witness, but he had some good tidbits for the defense to seize upon. Then you move on to the restraint itself. Was it justified? The defense needs to push that. They need to argue not only was it justified, it was certainly not a felony. It was not imminently dangerous because, they will argue, it was taught to police. It's something that, yes, you may have heard Chauvin's colleagues say, well, we don't like what we saw, but we called an expert that said this is something that was acceptable given the situation at that time and looking at all circumstances contextually.
All right, Danny, stay with us as well. I want to bring in Eugene Robinson in a moment just to reset where we are right now. We're waiting for this courtroom in Minneapolis, Hennepin County, to begin closing arguments today in the trial of Derek Chauvin. As we wait, let's bring in Washington Post columnist, NBC News political analyst Eugene Robinson. Eugene, I look at an op-ed that you wrote recently. You titled it "Chauvin's Despicable Defense." You clearly have a stance here, and I wonder what your take is on what today could mean for the larger community.
Well, look, the whole world is watching this trial. The whole world is waiting for the outcome, you know, to say something is potentially explosive, potentially a watershed moment, those sorts of phrases are overused. I don't think they would be going too far in this case. The George Floyd's killing resounded throughout the country and across the world, and was one of the sort of signpost events of our time.
Eugene, I'm going to interrupt. I'm sorry. We're listening to the judge now here in Hennepin County.
So members of the jury, I instruct you as follows. It is your duty to decide the questions of fact in this case. It is my duty to give you the rules of law that you must apply in arriving at your verdict. You have now heard the evidence, and soon you'll hear the arguments of counsel. At this time, I will instruct you in the law applicable to this case. You must follow and apply the rules of law as I give them to you, even if you believe the law is or should be different. You have each been given a copy of these instructions to follow along as I read, and you may take your copy with you when you retire to the jury room. Nevertheless, you should listen carefully and attentively as I read them to you now. Please note that the titles of the individual sections of these instructions are not a part of the instructions, but merely placed as headings to assist you in finding a topic. Deciding questions of fact is your exclusive responsibility. In doing so, you must consider all the evidence you have heard and seen in this trial, and you must disregard anything that you may have heard or seen elsewhere about this case. I have not, by these instructions, nor by any ruling or expression during the trial, intended to indicate my opinion regarding the facts or the outcome of this case. If I have said or done anything that would seem to indicate such an opinion, you are to disregard it. You must consider these instructions as a whole and regard each instruction in light of all the others. The order in which the instructions are given is of no significance. You are free to consider the issues in any order you wish. The defendant is presumed innocent of the charges made. This presumption remains with the defendant unless and until he has been proven guilty beyond a reasonable doubt. The fact that the defendant has been brought before the court by the ordinary processes of the law and is on trial should not be considered by you in any way suggesting guilt. The burden of proving guilt is on the state. The defendant does not have to prove his innocence. Proof beyond a reasonable doubt is such proof as ordinarily prudent men and women would act upon in their most important affairs. A reasonable doubt is a doubt based upon reason and common sense. It does not mean a fanciful or capricious doubt, nor does it mean beyond all possibility of doubt. A fact may be proven by either direct or circumstantial evidence, or by both. The law does not prefer one form of evidence over the other. A fact is proven by direct evidence when, for example, it is proven by witnesses who testify as to what they saw, heard, or experienced, or by physical evidence of the fact itself. A fact is proven by circumstantial evidence when its existence can be reasonably inferred from other facts proven in the case. For example, if a person watches deer crossing a snow-covered field, the person has direct evidence of deer walking in the field because the person sees it. If the person does not see deer but finds deer tracks in the snow, the deer tracks are circumstantial evidence that deer walked in the field because that factual conclusion can reasonably be inferred from the tracks found in the snow. Now, attorneys are officers of the court. It is their duty to make objections they think proper and to argue their client's cause. However, the arguments or other remarks of an attorney are not evidence. If the attorneys or I have made or should make any statement as to what the evidence is that differs from your recollection of the evidence, you should disregard the statement and rely solely on your own memory. If an attorney's argument contains any statement of the law that differs from the law I give you, disregard the attorney's statement. The state has brought 3 charges, or counts, against the defendant. Each count charges a separate and distinct offense. You must consider the evidence applicable to each count as though it were the only accusation before you for consideration, and you must state your findings as to each count in a separate verdict, uninfluenced by the fact that your verdict as to any other count or counts is in favor of or against the defendant. The defendant may be found guilty or not guilty of any or all of the offenses charged, depending on the evidence and the weight you give it under the court's instructions. I'm about to instruct you on the law that you are to apply to the charges in the defense, but before doing so, I am going to define a few words and phrases that appear more than once in the elements of the charges and the defense that follow. The words and phrases being defined are bolded in the written copy of the instructions you will be receiving. You should use these definitions for these words and phrases in your deliberation. Attempted means that the defendant did an act which was a substantial step toward and more than mere preparation for causing the result, and that the defendant did that act with intent to cause that result. There are several forms of bodily harm relevant to some of the charges or the defense. Bodily harm means physical pain or injury, illness, or any impairment of a person's physical condition. Substantial bodily harm means bodily harm that involves a temporary but substantial disfigurement, that causes a temporary but substantial loss or impairment of the function of any bodily member or organ, or that causes a fracture of any bodily member. Great bodily harm means bodily injury that creates a high probability of death, that causes serious permanent disfigurement, or that causes a permanent or protracted loss or impairment of the function of any bodily member or organ, or other serious bodily harm. To cause death, causing death, or caused the death means that the defendant's act or acts were a substantial causal factor in causing the death of George Floyd. The defendant is criminally liable for all the consequences of his actions that occur in the ordinary and natural course of events, including those consequences brought about by one or more intervening causes, if such intervening causes were the natural result of the defendant's acts. The fact that other causes contribute to the death does not relieve the defendant of criminal liability. However, the defendant is not criminally liable if a superseding cause caused the death. A superseding cause is a cause that comes after the defendant's acts, alters the natural sequence of events, and is the sole cause of a result that would not otherwise have occurred. To know, to have knowledge, or knew requires only that the defendant believes that the specified facts exist. Intentionally or intentional means that the defendant either has a purpose to do the thing or cause the result specified, or believes that the act performed, if successful, will cause the result. In addition, the defendant must have knowledge of those facts that are necessary to make his conduct criminal, and that are set forth after the word intentionally or intentional. With intent that, with intent to, or intended, means that the defendant either has a purpose to do the thing or cause the result specified, or believes that the act performed, if successful, will cause that result. It is not necessary that the defendant have this intent in advance. The necessary intent can develop during the commission of the act. Police officer means an employee of a law enforcement agency who is licensed by the Board of Peace Officer Standards and Training, charged with the prevention and detection of crime and the enforcement of the general criminal laws of the state of Minnesota, and who has the full power of arrest. A law enforcement agency is a unit of state or local government that is authorized by law to grant full powers of arrest and to charge a person with the duties of preventing and detecting crime and enforcing the general criminal laws of the state of Minnesota. The Minneapolis Police Department is a law enforcement agency for these purposes. The definition of any word or phrase with a specific legal meaning that appears only once in the elements or the defenses will be defined where it appears later in these instructions. The defendant is charged in count 1 with murder in the second degree in connection with the death of George Floyd. Under Minnesota law, a person causing the death of another without intent to cause the death of any person, while committing or attempting to commit a felony offense, is guilty of the crime of murder in the second degree. The defendant is charged with committing this crime or intentionally aiding the commission of this crime. The elements of the crime of murder in the second degree while committing a felony are: first element, the death of George Floyd must be proven. Second element, the defendant caused the death of George Floyd. Third element, the defendant at the time of causing the death of George Floyd was committing or attempting to commit the felony offense of assault in the third degree. It is not necessary for the state to prove the defendant had an intent to kill George Floyd, but it must prove that the defendant committed or attempted to commit the underlying felony of assault in the third degree. There are two elements of assault in the third degree. First, defendant assaulted George Floyd. Assault is the intentional infliction of bodily harm upon another, or the attempt to inflict bodily harm upon another. The intentional infliction of bodily harm requires proof that the defendant intentionally applied unlawful force to another person without that person's consent, and that this act resulted in bodily harm. Second, defendant inflicted substantial bodily harm on George Floyd. It is not necessary for the state to prove that the defendant intended to inflict substantial bodily harm or knew that his actions would inflict substantial bodily harm. Only that the defendant intended to commit the assault and that George Floyd sustained substantial bodily harm as a result of the assault. Fourth element, the defendant's act took place on or about May 25th, 2020 in Hennepin County. If you find that each of these elements has been proven beyond a reasonable doubt, the defendant is guilty of this charge. If you find that any of the elements have not been proven beyond a reasonable doubt, the defendant is not guilty of this charge, unless you find the state has proven beyond a reasonable doubt that the defendant is liable for this crime committed by another person or persons according to the instructions below that are listed on page 8 under the heading Liability for Crimes of Another. The defendant is charged in count 2 with murder in the third degree in connection with the death of George Floyd. Under Minnesota law, a person causing the death of another by perpetrating an act eminently dangerous to others and evincing a depraved mind without regard for human life, but without intent to cause the death of any person, is guilty of murder in the third degree. The defendant is charged with committing this crime or intentionally aiding the commission of this crime. The elements of the crime of murder in the third degree are: first element, the death of George Floyd must be proven. Second element, the defendant caused the death of George Floyd. Third element, the defendant caused the death of George Floyd by an intentional act that was eminently dangerous to other persons. A person commits an act eminently dangerous to others when the act is highly likely to cause death. Fourth element, defendant acted with a mental state consisting of reckless disregard for human life. The defendant's act may not have been specifically intended to cause death and may not have been specifically directed at the particular person whose death occurred, but it must have been committed with a conscious indifference to the loss of life that the eminently dangerous act could cause. Fifth element, the defendant's act took place on or about May 25th, 2020 in Hennepin County. If you find that each of these elements has been proven beyond a reasonable doubt, the defendant is guilty of this charge. If you find that any of these elements has not been proven beyond a reasonable doubt, the defendant is not guilty of this charge, unless you find the state has proven beyond a reasonable doubt that the defendant is liable for this crime committed by another person or persons, according to the instructions that are listed on page 8, under the heading Liability for Crimes of Another. The defendant is charged in count 3 with manslaughter in the second degree in connection with the death of George Floyd. Under Minnesota law, whoever by culpable negligence, whereby he creates an unreasonable risk and consciously takes the chance of causing death or great bodily harm to another person, causes the death of another, is guilty of manslaughter in the second degree. The defendant is charged with committing this crime or intentionally aiding the commission of this crime. The elements of manslaughter in the second degree are: first element, the death of George Floyd must be proven. Second element, the defendant caused the death of George Floyd by culpable negligence, whereby the defendant created an unreasonable risk and consciously took a chance of causing death or great bodily harm. Culpable negligence is intentional conduct that the defendant may not have intended to be harmful, but that an ordinary and reasonably prudent person would recognize as involving a strong probability of injury to others. Third element, the defendant's act took place on or about May 25, 2020 in Hennepin County. If you find that each of these elements has been proven beyond a reasonable doubt, the defendant is guilty of this charge. If you find that any of these elements has not been proven beyond a reasonable doubt, the defendant is not guilty of this charge, unless you find the state has proven beyond a reasonable doubt that the defendant is liable for this crime committed by another person or persons, according to the following instruction on liability for crimes of another. The following instructions apply to all three of the charges I've just given you. The defendant is guilty of a crime committed by another person or persons only if the defendant has played an intentional role in aiding the commission of that crime and made no reasonable effort to prevent the crime before it was committed. Intentional role includes intentionally aiding, advising, hiring, counseling, conspiring with, or procuring another to commit the crime. The defendant's presence or actions constitute intentionally aiding only if first the defendant knew another person or persons were going to commit or were committing a crime. Second, the defendant intended that his presence or actions aid the commission of that crime. If the defendant intentionally aided another person or persons in committing a crime, or intentionally advised, hired, counseled, conspired with,